The matter's ready. Your Honor, I'm appearing on behalf of Mr. Zandy this morning. He indicated we did receive those orders from Ms. Jocelyn yesterday. We have yet to have the opportunity to look over those orders and discuss with our client, so we were going to be asking for a set over this morning.
Ms. Jocelyn, any objection?
Yes, Your Honor, we have the issue of a GAL report that needs to be done prior to 12/12. The GAL that we're going to use, Ms. Turnbull, needs a very tight turnaround to be able to do that. I had also sent in proposed orders for the original hearing that we never got a response to. The orders are very simple. Stop child support, order a GAL. There's nothing really to contest. And if we set it back 2 weeks, then it's going to be impossible for the deadline that we've set for the GAL. The order should have taken no more than a whole 2 minutes to review.
And again, Mr. Zandy indicates that he just received those orders yesterday, so he had no opportunity to review them before this morning's hearing. I understand that we do need a tight turnaround. A week so should be suffice.
It's super quiet.
Okay. Wait until your case is called, please.
Yeah. Your Honor, if we even wait a week, that it's going to be impossible for the 12/12 hearing, which is the hearing date.
We're appointing GAL, I'll hold the other until next week.
Okay, so we are going to sign the order for Ms. Turnbull.
Yes.
Thank you, Your Honor.
Thank you, Judge.
And same time next week, Your Honor, for the temporary orders.
I'm sorry?
You said same time next week to go on the temporary orders?
Yes, ma'am.
Okay, thank you. And so we are free to contact Ms. Turnbull to start this?
Okay, yeah, that order is signed and we'll hold the other.
Okay, thank you.
All right, go ahead.
And for the record, Megan Gilmore on behalf of the petitioner and moving party, namely Jordan Kenaway. This matter is before the court on my client's motion for contempt. A final parenting plan was entered in this county on September 30th, 2021 that names my client primary parent and provides father alternating weekend visitation. The court also entered a child support order at the same time, I believe at the end of September of 2021, that requires father to pay $100 in child support. My client first brings this motion for contempt as father refused to return the children as detailed within her declaration and in direct violation of the parenting plan. Father sought a protection order in Clark County alleging that the child had a bruise on his bottom. He claimed this occurred on September 15th, but didn't file the petition for a protection order until October 9th and never addressed the allegation or concern with my client in the interim. He also alleges that he was aware of criminal allegations against my client's husband for over 4 years prior to bringing this petition. Despite the parenting plan being in Cowlitz County, as well as my client and the children residing in Cowlitz County, father sought a protection order in Clark County. Not only did he file the protection order in a different county, but father intentionally failed to include under Section 10 of that petition the fact that we have a final parenting plan and custody order in this county. We believe father intentionally misled the court by failing to disclose that there's an order, and father doubles down on this failure to disclose by then including the criminal allegation or the criminal cause number under Section 10, which alludes to a different county that the children or my client of this action were involved in the criminal case, which is frankly not true and undisputed that my client didn't even know her husband when this criminal allegation occurred. Father request for a protection order was denied the same day that he filed on October 9th, as submitted within the denial order submitted by Judge Lewis. My client exchanged the children on October 13th pursuant to the parenting plan with no knowledge that he had filed anything or there was any sort of allegations whatsoever. Father's trying to claim that my client is some sort of trying to mislead the court, even though she wasn't even before the court. He addresses social media posts and other excuses, claiming that my client continues to be in a relationship, but frankly, that's really irrelevant for the purposes of this motion. And more importantly, my client wasn't even aware that there was some sort of allegation being made to even an attempt to mislead this court. On October 17th, despite being on notice that he had received a denial order that he didn't have any sort of standing to keep these kids, father refused to return the children. Father's own responsive materials indicate text message correspondence where my client saying, "Hey, come to my home. I'll show you that Nicholas isn't there." And he still refused. He then not only refused to exchange the child on Sunday the 17th, but then he didn't take the child to the school the next day, indicating within his own materials he didn't want my client to have access to the child. After retaining me and frankly threatening criminal liability, father finally returned the children on the 17th, the following day. My client explains in the declaration that on the 18th, the next day, father took it upon himself to take her address information that he had supplied to her and contact the school district, asking them to file fraud against her because of the new address. My client is a part of the transitional housing program, and this thankfully didn't impact the child, but ultimately these allegations are only hurting the child, not my client. At a recent visitation, this 5-year-old has expressed frustrations with his father because he's interrogating him to get information about my client's home. By way of update, we were before the Clark County Court on Monday. The court denied both protection orders against my client as well as Mr. Kenaway. At this point, we ask the court find contempt because father has acted willfully, intentionally in violation of the court's order. We ask the court considers a substantial award of attorney's fees, as we believe that the refusal to return and frankly the protection order was brought in bad faith. My client has expended about $5,000 at this point to get her kids back, to defend a baseless protection order, and to support a motion for contempt. And we do ask the court to consider entering a subsequent orders that neither parent should involve the children in conflict or disparage the other parent to the children. Looking to support, the orders are clear. He had a $100 obligation. He doesn't deny that he hasn't paid $1 of that since the order was entered over 2 years ago. My client denies ever agreeing to modify that order in any way. Father shows receipts for contributions of expenses over the entirety of this order, totaling $162.47. At this point, we believe that he currently owes basic support of $2,500, as that's 25 months at $100 that he's failed to pay. But if the court would like to credit that to the $162 to him, I have provided that math within our responsive materials. Again, we do ask the court find contempt for both the violation of the parenting plan as well as the child support order and consider substantial fees. Thank you.
Ms. Holder?
Good morning, Your Honor. Amanda Holder here representing Mr. Junk. First of all, in order to find Mr. Junk in contempt, there would need to be an act of bad faith, and that is not the case here. As to Ms. Gilmore mentioning the protective order and saying that the protective order was in bad faith, that's not what's in front of the court. It is about Mr. Junk holding on to his children after Ms. Kenaway's husband's protective order was granted. So there are two issues here. The first is the withholding. My client did not withhold the children out of bad faith. It was because he had a reasonable belief that Mr. Kenaway, Miss Jordan Kenaway's husband, was still in the home and that the children were in danger. Mr. Kenaway has a conviction for DV4 and DV2, where he abused his own 2-month-old child. That child suffered fractured ribs, fractured wrist, bruising, linear markings on her neck and back, and he admitted to investigators that he did those things that brought about that harm. We originally intended to file the protective orders in Cowlitz County, and the Cowlitz County Clerk's Office directed us to file in Clark County, and that was because there was not an address on record for Miss Kenaway in Cowlitz County, and the children that would be protected lived with their father in Clark County. So the Cowlitz County Clerk's Office saw that the appropriate jurisdiction to file the protective orders were in Clark County, so that it was not brought in bad faith and it was not done to mislead the court. Additionally, the case file was mentioned and labeled and listed in client's declarations in those protective order hearings, and so it was not to mislead the court. It was listed. It was not to say that the children in this case were in had nothing to do with that case. It was clearly disclosed and there was no misleading of the court. As far as originally filing, we wanted to file on the October 6th date. Mr. Junct became aware of the criminal conviction after his son came to him in September of this year with bruising and said that it was Mr. Kenaway that caused the bruising. Mr. Junct immediately started looking for an attorney because not only did he want to file protective orders, but he also wanted to possibly modify the parenting plan so that he could retain custody as he was concerned with his children. So we filed on, we wanted to file 10-6. We were directed to file in a different county, so we did. That was Mr. Junct's weekend with the children. So then we ended up filing that following Monday on the 9th. Mother and Mr. Kenaway had custody of the children for that week. So Mr. Junct decided to just not serve them until the 14th because as per Mr. Kenaway's own what he said to investigators was that when he gets frustrated or upset, that's what caused the injuries on the children. So Mr. Junct made a decision not to serve the parties until a few days later so that tensions wouldn't erupt and that he wouldn't have to worry about the safety of his children any more than he already did. Then we ended up serving them on the 14th, and that was Ms. Kenaway's denied protective order, but Mr. Kenaway's granted protective order. Mr. Kenaway was served at the address that Ms. Kenaway claims that she lives at on her own, and he was served that on a Saturday morning at 10 a.m. Further, there are records from the child's daycare providers that Mr. Kenaway was dropping off the children early in the morning and picking them up late in the afternoon, indicating that he still lived in the home with Ms. Kenaway. The social media posts are not irrelevant, despite what Ms. Gilmore might say, because it listed and described Ms. Kenaway said that her husband was Nick Kenaway. And then when she was served with the protective order, she then went back and changed it to remove the word my husband and just say he. So there was enough reasonable belief for my client to lawfully withhold the children because he was extremely concerned that Mr. Kenaway was still living in the home. And Ms. Kenaway never told Mr. Junct that the parties were separated until after the protective order was filed and served and was approved for Mr. Kenaway. And then it was very convenient for Ms. Kenaway to come back and say, oh, we're not together anymore, give me the children back. The exchange was done, and Mr. Kenaway did give Mr. Junct did give the children back on October 17th after adequate assurances were made by counsel that Mr. Kenaway was no longer living in the home and that Ms. Kenaway was the only person on the lease of the apartment. After that, it was discovered by my client that it's likely the reason that he's not included on the lease is because he's a convicted felon, and that could impact their ability to live there. As far as Mr. Junct going to the school and saying that there's fraud, that's not what happened. Mr. Junct went to the school to get his son's school records because Ms. Kenaway did not provide the parenting plan to the school. Therefore, he could not access the school records of his own child, despite the fact that the parenting plan says they have joint decision making. So he went to the school and he found out that Ms. Kenaway was using her mother's address to put her son in a school district that he did not belong to. And at that point, Mr. Junct said, I'm not sure what's going on here. The wrong address was used. I'm not saying there's fraud happening, but that's kind of what it looks like here. So as far as the child support issue goes, both parties were acting under a misunderstanding that child support was not supposed to begin until this fall. There's a text message, and that is from September 3rd of this year, that Ms. Kenaway herself says, I'm guessing part of this is coming up due to the fact child support is supposed to be starting soon, meaning she did not believe it was in place. Mr. Junct has never not been supportive. He has given money. He has even asked, hey, do you need some money for the kids? What's going on? Let me help you. So there was no bad faith here. What is interesting is that this is the first contempt motion that has ever been filed in this parenting plan that has been put in place since 2021. The first contempt that was put in, that was filed, was 4 days after Ms. Kenaway and her husband were served with protective orders. This is a retaliatory motion, and my client did not act in bad faith, either on the child support, as both parties were acting under a misunderstanding, and Mr. Junk was extremely worried about letting his child and his children in the home of somebody who has a convicted, who's a convicted felon for child abuse. Further, we did go to court this past Monday, and Mr. Kenaway's protective order was denied. We have filed for a revision, as we do believe the commissioner got that one wrong. So we would ask that this contempt motion be denied.
Ms. Gilmore?
Just quickly, Your Honor, I think the timeline really looks to the underlying intent of father. The criminal allegation against my client's husband happened prior to her dating him in 2018. My client started dating him, I believe, around 2019, about 4 years ago. My client provided notice of this ongoing criminal liability of her significant other at that time. Father had no concerns. Then the parties enter an agreed parenting plan in 2021. That parenting plan transitions from father having a 50-50 schedule to having alternating weekends in the fall of this year. Then conveniently, we have the allegation made by father that this child has a bruise to create a nexus between the criminal liability and my client's husband. Again, there is some argument that he didn't know the criminal conviction until after the disclosure of the child. That's not accurate. That's not what was portrayed in the declaration. He was aware of the criminal liability way before that. And we believe that, again, he's using child hearsay alleged statements to create this nexus to support a protection order that was ultimately denied. So we have to look also to the reliance on the orders. That he failed to present sufficient information for a protection order in Clark County. He failed to intentionally disclose the parenting plan. Ms. Holder even acknowledges that he was using the protection order to circumvent the parenting plan. He had no authority to keep the kids. My client was more than forthright that she wasn't living with Mr. Kenaway. She literally was willing to drive with him up to Cowlitz County to show her residence. And she explains the fact that they have a child, Mr. Kenaway and her have a child in common. He was at the home to discuss visitation at the time he was served. I assured counsel that my client wasn't living with him, and there was still a back and forth about exchanging the child. So we do believe that this failure to exchange was done in bad faith. And on the child support, an order is an order, and he failed to comply with it. And he doesn't deny that. So even if the court's not willing necessarily to find a contempt because some sort of notice issue, I asked the court enter a judgment for the amount owing, because it's amount owing that it was not modified.
All right, well, the legislature has created a process that I think looks to most people like a way to end run parenting plans, and not surprisingly, it gets used for that a lot. But the bottom line is there were pre-existing court orders in this case that covered A, child support, and B, the parenting plan. If Mr. Junt felt that the temporary protection order that was granted was in some way being violated, his recourse is to contact the police. It's not to just take it upon himself to decide that he doesn't have to follow the parenting plan. I'm not going to add any contempt order as to the child support issue. However, obviously we have a past due amount, and Ms. Kenaway is entitled to a judgment for that. I am going to find contempt for withholding the child. I guess the best way I can put it is, having said that, it doesn't seem to me like anybody involved in this comes here with entirely clean hands. I'm going to order attorney's fees of $500. Presentation in a couple of weeks, counsel.
Okay. Just quickly, Your Honor, is the court giving him a credit for that $167 or whatever it was that he paid for undescriptive since? Okay, I will adjust that. Thank you.
All right, thank you.
Plan hearing. See how it goes. Why they can be getting moved out?
Mr. Alton, anything you wish to say in addition to what's in your paperwork?
No, I just, I'm hoping we can figure something out because this continues on. It's happened again this last weekend. I'm sorry, I'm really sick right now. It's happened the last weekend. It's happened 3 weekends in a row now where she's overtaking her time from me. So that's, I don't have much.
Ms. Keef, anything you want to say?
Last weekend I told him that we were going to go to the hospital because Landon was coughing and puking up blood. And so we went to the emergency room and Garrett decided to meet me afterwards. Also the time before that, he agreed to meet me at 5. And then the first time I completely read the parenting plan wrong. And I thought that if Landon wasn't at school, it was drop off at 6, not 9. So I did mess that one up. But I mean, I was taking him to the emergency room for puking up blood. He's been having an ongoing stomach issue that Garrett's neglecting.
Mr. Alton, anything you want to say?
Yeah, he had a bloody nose is why he coughed up blood. We went to the doctors and had a doctor appointment. He's also went to a specialist and had ultrasounds and lab works and blood tests done, and everything's 100% normal.
It wasn't a specialist. It was an ultrasound technician. And he didn't have a bloody nose at my house when he was coughing up blood.
Yeah. I just said this in the last case too. The short and simple answer is you folks have a parenting plan. It specifies what you are to do and what time you're to do it. You've got to follow. End of story. I am going to make a finding of contempt against Ms. Keef. I'm not going to order any fees at this point in time. Mr. Alton, you need to prepare that order. We'll put this on for November 30th for presentation. And Ms. Keef, look at the parenting plan carefully. Do what it says.
Okay.
That will be all.
Thank you.
Thank you.
So, Mr. Ellis, as near as I can tell, you don't like the parenting plan that got entered.
No, you and I and Heidi and the gal met to review the guardian ad litem's final report about 2 months ago.
Mm-hmm.
And in that, the supervisors were removed for the 3 littlest children. And at the time, yes? Yes?
Go ahead.
At the time, you didn't want to make changes to any of the days or hours, but you did want to give me the unsupervised time with the children. And the end result was that my time with the children was cut in half across the board inadvertently. You suggest that I could submit for a new parenting plan. All I'm doing in this proposal is trying to get back the same hours that I had previously to the removal of the supervisors.
All right. And so now let me finish what I was saying. In order to make a change to the parenting plan, you've got to file a motion to modify. You have to give Miss Ellis notice of that and provide proof that she's been served with that motion, and a notice of hearing showing when it's going to be on for. So unless and until you do that, there's not much I can do. I understand that the process through the court system, the pleadings that are necessary, is kind of confusing and daunting to somebody who doesn't have experience with it, but I am required to follow those rules. So if you want to change the parenting plan that was entered in October, you've got to file a motion. You've got to support that motion with whatever reasons you think are appropriate. You have to set a hearing, and you've got to give Miss Ellis proof of those things. You understand that?
Okay, I believe I've done all that, so can you help me? I submitted a proposed parenting plan. I'm sorry?
You submitted a proposed parenting plan. There's no motion. There was no notice of hearing. I've got no proof any of it was served. So without a motion to modify the parenting plan, I can't do anything.
All of those were done the parenting plan, the declaration, the motion was the cover sheet on this. We set the docket. We served both the
Mr. Ellis,
guardian ad litem. Yes.
Ellis, I don't know how else to tell you this. There's no motion that was filed to modify. Absent that, I can't do anything. So that's where we stand. If you want to pursue it, you need to file that motion, serve the motion and a notice of hearing, and then I will happily look at whatever it is you're requesting. That will be all for today.
I have a question really fast.
Yes, ma'am.
Because I was gonna ask for a continuance because our GAL couldn't come to this hearing. Should I just cancel that continuance
I'm
then?
not going forward with any motion today, so if there's one filed in the future, I will look at it.
Okay, thank you.
I don't have them here. All right. Ms. Ebert, I'm told that there are orders that came back to the court, but I don't have them in front of me. I'm going to step down for just a moment, go see if I can locate those, and I'll be right back in.
Okay.
I don't know what to do with myself.
Okay, Ms. Ebert, I found the paperwork, so give me just a second to take a look at it.
Okay.
So, ma'am, are you receiving any sort of assistance for the children from the state?
The only assistance I'm receiving is EBT food. And the kids are on medical.
Okay. So the one issue that we've got is because of that, the state has to be involved in the child support issue. You need to contact the prosecuting attorney's office, their child support division.
I
And
thought we did that.
Yeah, we already did that.
okay, doesn't look like anybody from the state is
They
present.
said- I got a letter saying that they weren't going to represent or anything, but I did do the child support paperwork like they asked. And I brought the letter in. They should have had a copy on file.
Wait, okay, I see something here.
Yes, Chad. Yes, Chad. Where's Chad?
Okay, so on the child support order, I'm going to strike the language that says Mr. Ebert's not ordered to pay any child support. I'm checking the box that says public health care coverage because you enroll the children in public health care. You understand?
Yeah.
All right, if you'll both raise your right hands, please. Do you swear to tell the truth in this proceeding?
Yes.
And you both signed all these documents, is that right?
Yes.
And you've reviewed and signed these as well, Mr. Ebert?
Yes. I do have a couple questions about the parenting plan though.
What's that?
Now I just want to make sure that nobody can take the kids out of state without permission.
Nobody can move out of the state without permission or without a court order, but it doesn't prevent somebody from, going to Portland.
Oh, no. I get that. I just wanted to make sure.
Okay. That answer your question?
Yes, sir.
And ma'am, let me ask you, let's see, when did you
June
June of
20th.
this year? Okay, and is the marriage irretrievably broken?
Is the what? I'm so sorry. I didn't hear you. What?
Is the marriage over?
Yes.
Okay. And is there any property or debts that you need to split that aren't listed here?
No.
Sir, you were nodding your head. Is there an issue about that?
I'm not 100% sure about the debts and stuff like that. I still am trying to figure everything out with that and that aspect of it.
Okay, if any debts show up that aren't disposed of here, you're both still on the hook for it. You understand that?
Yes.
And if you owe any third-party money, anything we do here today doesn't change the fact that they can chase both of you for that money.
Yeah.
Okay.
I didn't know I could.
And is this the parenting plan that you've been following already?
We haven't started following it because it was originally a proposed parenting plan at first. We were told to not start following it until this hearing, after this hearing.
Okay. And Mr. Ebert, you're in agreement with this parenting plan?
Yeah.
There is one thing I'd like to mention though, Judge.
Yes, ma'am.
So I understand Spencer will be having the kids on the weekend. But I would like to make it known, if it's possible, that he has to establish a residence within 60 to 90 days to have those overnight visits, because he is currently living in his truck.
Is there any problem with that, sir?
A little bit, you know, it's not like, so I get the kids every other weekend. It's not like I can't get a hotel room for the weekend, or yeah, I do stay in my truck, but I do go to work, and it's not like I don't have money rolling in or anything like that. A hotel room wouldn't be an issue.
Great.
I am currently looking for a place. Don't get me wrong. I am looking for a place, and yes, currently at the moment, I do stay in my truck.
All right. Well, obviously that's not, a good situation for a 5 and a 4-year-old. So you need a place physically to take the kids, and Miss Ebert's entitled to know where that is. So make sure she's got that information anytime you are taking the children for your visitation. Understand that?
I wouldn't not tell her where I was going.
All right. Then I will grant the decree. I've signed all the paperwork, and that will be all.
Thank you.
Thank you.
I'm doing a thing over Zoom. Sorry.
Mr. Anagnostou?
Yes, Your Honor. I'm here on behalf of my client, Kendra Rapp, the mother. And at the last hearing, you indicated that you wanted the petitioning parties here, or else the matter would be dismissed. My client's here, and I don't know if the petitioning party. Oh, she's waving her hand apparently. Okay.
All right. Do we have Miss Doble or Mr. Doble?
Yeah, it's Woodruff. I'm sorry. It comes up Cody Doble every time I do a Zoom meeting. I don't know how to change it.
Okay. What is the status of the full guardianship?
I believe I have turned in everything that I've needed to turn in.
Is that set? Is that set?
I'm not sure, Your Honor.
Well, that's my concern. We can only go under this emergency guardianship for so long.
Correct.
And we're, 7 months in?
Yeah, from my understanding, we're waiting for the case report from our GAL.
Pardon?
I think we're waiting for our case report from our GAL, from my understanding, is what's been getting pushed for so long. That, and I did miss court last, and I am sorry, and I apologize for missing court.
So have you filed for a full guardianship at this point?
Yes, I believe I have, yes.
Do you believe you have?
Yes,
Did you start a case for the full guardianship and file it with the court?
yes,
And is there a hearing date set for that?
no.
Your Honor, I haven't received any documents on the full guardianship. She hasn't served me.
Ms. Farr, where do we stand from your?
Yes, Your Honor. Good morning. So the petition on the full guardianship was filed and served back in March. And we are waiting for me to complete my report in this case for it to go forward. I believe that the hearings have been continued, waiting for my report, and it has not been set for a hearing on the full standard petition yet.
And where are you in terms of your report?
I am ready to prepare it, and I apologize that I haven't done it yet. I have said the last two hearings that I'm just needed a little more time, and I am still here again asking for just a little more time. I should be able to get it filed within a week or two.
Mr. Adamowski?
Yes, looking back through the file, there is a minor guardianship petition that was filed on March 8th. I had overlooked that because with these conversations, I thought we were starting new with regards, but in any event, my client is requesting expansion of her residential time until we get have a full hearing on this. We've come before the court a couple of times to ask for additional time, and it's been continuing based on the guardian ad litem not completing a recommendation at this time. So my client would like to see additional residential time while this matter proceeds. And we do need to get some kind of end date for the full guardianship.
Your Honor, the visitation was expanded at mother's request.
Well, Ms. Farr, are there any barriers to getting your report done at this point?
It's just my own personal time constraints with the caseload that I have. I can make this more of a priority and get it done within a week or so.
And what's the current visitation?
It gets I believe it's a couple hours a day or a couple hours on a weekend. She doesn't get an overnight is my recollection, but I'm looking for that at this time.
Correct. Your Honor, it's every other week for a 2-hour visit. Mom has been attending her sporting events that just ended less than a week ago, actually, and she was attending those as well.
So has she been attending the visit?
Yes, visits have been going well. They always have with mother. Visits have never been an issue.
Okay.
On behalf of my client, we would like, sometime every week and an overnight would be preferred, like a Saturday to a Sunday.
Your Honor, for me to accept overnights, I would mandate drug testing and mental health testing, and that's why we're at the standpoint where we are now.
Yeah, Your Honor, I would just ask that if you could just give me another week or so to get the report in, and then you would have a better idea of what the issues are.
At a minimum, we'd request at least visits every week. This every other week is not warranted.
Well, she is visiting more often than that because she's attending the child's sporting events as well as the 2-hour visits.
That's not really a visit.
How are the visits going, ma'am?
Your Honor, they go good. She visits with the kids. Well, I have both siblings. I'm not allowed to talk about the other child, but she gives time to both of her kids. Visits go good. She does either baking or crafts or something. We generally do them either at a public place or at her residence, her dad's house, where, you know, they hang out with mom, cuddle on the couch, watch TV, whatever the children want to do. She's involved. The visits go well. My only issue is her other child is only having a visit every other month for a 4-hour duration. So it gives my household this confusion of why one child is getting more visits than the other. That's, yeah.
And my understanding, that's a separate issue. That child is under.
Correct. Separate issue, but same mother and father for both children.
It's not part of this case. This case is only with regards to Shyla.
Okay, so any reason as between now and a couple of weeks from now, we can't have a visit every weekend?
Not other than upsetting the son that she has. No, Your Honor. Her other child is my concern is his emotional well-being.
I am really flying blind at this point. Ms. Farr, I really need that report in June. You said it'd be ready in July, so we've got to have that.
Yes, Your Honor. One of the problems was that I had to follow up with mother, and mother was in jail for a short time. Mother also took a month vacation to go to Hawaii. So, you know, I did my best to try to get these follow-ups done, but it took time.
Yeah, I think my client did have a vacation to Hawaii, but that was in July.
Mm-hmm.
Well, I don't think I've got a whole lot of choice at this point. I am not going to make any specific change to the August 23 order. Ma'am, all I can say is use your best judgment about how the other child's doing. And if you can make extra visits work, great. I will put this to November 30 because 2 weeks is the 23rd. Ms. Farr, that report has to be in.
Yes, Your Honor. I will have it done by then.
All right, that will be all.
Good morning, Your Honor. Mallory Smith, court visitor.
Amy Powers for the state of Washington.
I see that Mother Miss Tesla Ivy is available also. I received a text message from the guardian, Miss Kendra Yasanovich. Miss Yasanovich indicated that she currently has COVID. She's been trying to log in, but is having technical difficulties as well. She's not able to bring the court paperwork in for presentation. I would defer to the court whether you would prefer that we set this over a couple weeks or.
She's present now.
Miss Ivy, everything going as it should as regards to visits and that sort of thing?
Yes, Your Honor.
Okay, and no problems from your standpoint?
No.
Okay. Yeah, she was under the weather last week when we had this hearing, so that.
Yeah, apparently her and Braden have COVID right now.
Okay.
She just messaged me this morning.
Okay. Then let's put this on for a presentation of that order November 30, since it sounds like everything's going well. And Miss Ivy, has there been any discussion about the Thanksgiving holiday?
No, there's been no discussion on that.
Okay, well, yeah, I assume there will be some. It sounds like it's not going to be a problem for you guys to sort out what will happen over that holiday based on what I'm hearing. Would you agree?
Yes.
Okay, then we will set this for the 30th for presentation of that order.
Okay, at 10:30.
All right, thank you.
Thank you.
And Mr. Anagnostou, Ms. Bliss. Let's see. I think we've got most everybody here. Where do we stand?
And Attorney Dino Koyak is here on that matter as well, representing the father.
Yes, sir.
I guess I can provide a brief update. I did have the opportunity to speak with my client. The parties were going to attempt kind of an informal settlement negotiation. I did send an email to Mr. Anagnostou about that issue yesterday. So I would kind of defer to him as to how we proceed with regards to my client's rendition of what's been occurring lately. There have been letters exchanged between mom and my client. I believe one letter both ways. Mom has not utilized the texting provisions that are under the current order and has not communicated with my client absent. There was about a 3-minute video sent to her earlier this week, but absent that, there hasn't been much correspondence.
So it's my position, Your Honor, counsel and I have been discussing an opportunity for my client and Ms. Bliss's client to have a conversation, basically a settlement discussion to see if we can come to some kind of resolution with regards to contact between my client and Ms. Bliss's client, the minor. And so we were trying to arrange a time, and the email that I saw talked about school schedule and potentially tomorrow, which is it's a holiday, and so it's just a matter of arranging time for us to have that conversation to see if the mother and the daughter can mend their relationship.
Mr. Anderson, we've got a cover sheet for completion of the Guardian training, but I can't tell if it was Mr. Jones, Miss Jones, or both.
I believe both, Your Honor.
Okay, it doesn't indicate one way or the other.
I understand. It's my understanding that both have been completed, and my name is Ken Anderson. I'm representing the petitioners. They're very concerned about the transportation for the visitation for mom. The child goes to school. It's an hour there and an hour back. So if some consideration could be made there, it's part of the order of the emergency order back in October. And then as I reviewed the file as well, I'm concerned that I haven't looked, but the letters of guardianship may have expired on the 2nd of this month. The way that the order was phrased, the letters of guardianship. So we would request that the letters be extended if necessary. Thank you.
Yeah, that's the indication on the emergency order, is it expires on November 2nd.
And Your Honor, I believe Ms. Commissioner Baldwin, when she initiated these orders, when we had the full hearing, had set that November, I think we were before the court last week on the 2nd, and set it as essentially a review hearing to see how the visits were progressing, because you can see under the emergency order, there is kind of a step plan in place. So it's my understanding that the November expiration was essentially contingent upon that review hearing that was set to occur last week. The parties all agreed to set it over to this week's in hopes that Mr. Anagnostou and I could come together to discuss a formal settlement. So, I mean, I would concur with Mr. Anderson that the letters should continue at least pending the next review hearing, if we set another review hearing after Mr. Anagnostou and I are able to convene.
Okay, well, this is, we are now in the 4-month mark on this case, so we do need to get it resolved. I'm willing to extend the emergency order for another 60 days. And I'm going to suggest that in the meantime, counsel get those issues sorted so we can get a final order entered at our next hearing.
And Your Honor, if I may be briefly heard.
Yes, sir.
Attorney Dino Glick here on behalf of the father. Communications between my client and the minor have been going well. They have attempted a couple of times to do a visitation, but unfortunately, my client has to rely on the petitioners for transportation, and just things have come up, so that has not happened yet. My only other request for the court besides the update is At this point, my client has signed a consent to the guardianship, so I would ask to be or the court's permission to withdraw from the cases. I don't think I am needed any further.
And I would grant that request.
Thank you, Your Honor.
All right, I will sign a new order that extends the guardianship through January 4. Mr. Anderson, if you'll submit that, and we'll set a hearing on January 4, hopefully to enter agreed orders.
And Your Honor, if I may, Sherry Farr, the guardian ad litem, I was appointed in this case, but I wasn't notified. I only learned of it last week. And it appears that the attorneys are no longer believe that I am needed. So I'd like to be discharged as well.
Anyone object to that?
No objection.
No objection.
No objection.
No objection, Your Honor.
All right, and Ms. Farr is relieved as well. Thank you.
Thank you.
All right, January 4.
And then, so I understand we're setting it out January 4. Are we going to set this hearing with regards to residential time over for a couple of weeks? Ms. Bliss and I again are trying to work out a time, and I haven't heard when we are going to try to make that happen. Where my client,
what I'd like to do is let's just leave the January 4 date, and counsel, if you can't get an agreement reached, any of the parties can note it back on just on a notice of hearing.
Okay, very good.
With them.
Yes, Your Honor.
Thank you, Your Honor.
All right, counsel, where do we stand?
Your Honor, we are also working with Ms. Farr as the court visitor on this matter. I believe she, given her schedule, she hasn't had time to complete her investigation. We did get one extension, but we also yesterday served and filed and served a standard guardianship petition so that we could extend the emergency guardianship orders under the requirements of the statute in order to allow Ms. Farr to complete her investigation. I'll also report to the court that the parties have agreed that the child will spend a couple of overnights with his mother over the Thanksgiving holiday. So there is some visitation time that we're working out.
Ms. Jones, anything you would add?
Good morning, Your Honor. Thank you. That is correct in terms of the procedural posture of the case. I believe Ms. Farr and my client, the respondent mother, Marlene Melton, have their first interview scheduled on Monday, November 20th. So not next week, but the week of Thanksgiving. So I understand that the investigation is underway based on Ms. Farr's caseload and what she's able to complete based on the load of the caseload that she has. And we have agreed to some overnight visitation for Thanksgiving. And the only other matter I guess I wish to raise during court is potentially some kind of visit this upcoming weekend, whether it be daytime or overnight. That would essentially create an every other weekend time contact between the child and the mother until the soonest date that we all discussed, at least for now, was the 30th of November. Not sure if Ms. Farr is able to complete a report by then, but that was the soonest date that I was available to appear on this calendar.
Ms. Farr, where are we?
Your Honor, I'm still conducting interviews, and as Ms. Jones said, and we did talk about an 11:30 review date for the extension.
Your Honor, if I may, I think it's probably premature to say that we are establishing an every other weekend overnight visitation pattern. My client has offered for Thanksgiving for the holiday, but I would prefer if we could hear from Ms. Farr before we enter anything that looks like an agreement for a particular schedule, other than the telephone calls.
All right, I will set the matter to November 30th then, and we will extend the letters through that date. It sounds like the parties are working together to establish contact, and I don't want to interfere with that at this point. Absent better information. So I'll just leave that to the parties to try and work through. It sounds like you've got Thanksgiving sorted. So it's not too much longer out to the 30th. And we'll address anything more formal at that time.
And Your Honor, I will drop an order for the extension off at the court today.
All right, thank you.
Thank you.
Thank you, Your Honor.
Your Honor, Sherry Farr, guardian ad litem. I'm on this one as well. Not seeing any of the other parties though. We had all talked about and agreed to an extension on this one as well. Do
we have Ms. Lake?
So we had circulated emails and everybody agreed to the 30th. And perhaps the attorneys just believed that that was adequate. I'm not sure, but that was what we agreed to.
I don't see Ms. Lake or Ms. Young, so I will assume that is the case, and I'll move this to the 30th.
Thank you.
Thank you. And see Ms. Conley.
I'm here.
We have Ms. Strong or Mr. Hall.
They had been served, Your Honor.
I don't have any proof of service.
Because of some issues that happened in Alabama. There was a delay, and there was a delay in me getting all the way back home so far. I do have it here. Someone tried to bring in a copy, and I understand you don't accept that, but there seems to be a jurisdiction issue. So at this point, I would like to know if I can please have a jurisdiction hearing, and that the case please remain open in Washington temporarily until the jurisdiction issue gets resolved.
So are there some court proceedings going on in Alabama?
Not as of yet. That is being worked on.
Okay, if and when there are court proceedings in Alabama, then there would be what's called a UCC-JDA conference between judges in both places. But we can't do that at this point. Where's the child at this point?
The child is still in Alabama. They gave her to me, but then somebody tried to say that the dates weren't correct on my paperwork, which was one of the stalls. I do believe that they were shown that there was a thing today. I can't speak 100%, but since I did see them at the sheriff's department, I'm going to have, that is my assumption. I know that is not a good thing. But because of all the issues that happened on Monday when I arrived and was told different things, I went and I had them mailed to all parties, certified and regular. I sent a copy back home. I understand that couldn't be accepted, but they have been served. So I have been told to ask that it be held open temporarily in Washington, and that I ask for a jurisdiction here. That's
well, yeah, at this point, I don't know if we have jurisdiction or not over this child. If the child's in Alabama, we don't. But I can't rule on anything today because I don't have proof anybody's been served with anything.
So can this
all I can do today is strike the hearing. And if you want to continue to pursue the matter, you'll have to set it for a new date, give them notice of that hearing, show proof that they've been served, both with that notice and with the original petition.
Okay, so
yeah,
so
unfortunately I can't do anything at all today.
So when I do get back home,
load it back up.
Okay, so then just get new paperwork is what you're saying?
Essentially, yes, and you got to have proof that they've been served with it. The parents have.
So even if I got home soon, that this still wouldn't hold up. I'm just asking questions because I'm nervous and
I understand that,
and after seeing my granddaughter, I'm definitely not stopping because I just can't stop.
You're going to have to set a new hearing date and provide the court proof that they've been served with the original petition and that notice of hearing. And then the issue of whether or not Washington can do anything if the child's in Alabama will have to be addressed. But
So ask for the jurisdiction hearing at the refiling time, or is that something that can be done now?
well,
Or-
yeah,
I'm sorry.
at this time, I don't have anything to show I've got jurisdiction over
Okay.
the child's in Alabama. You may want to pursue your matter there if that's where the child is. But what I'm
Okay.
saying, before I can do anything, the other side's got to get notice of it.
That they were served.
Yeah.
Okay.
Okay.
Thank you.
Thank you, ma'am.
How do I?
And do we have Melissa Royer or Kevin Royer?
Your Honor, Mr. Royer did contact my office yesterday, and he stated that he would not be able to get to the hearing today. He is supportive of the guardianship, but he would like time to respond.
Okay, I see one person on the screen that says R. Royer's iPhone. And who?
Your Honor, I believe that is Russ Royer, and that is the paternal grandfather in this case.
Okay, thank you. And we still don't have service on the mother, is that correct?
That is correct. We have sent her service, but the timeline for service has not yet expired. And so we would ask for a set over to give her time to respond, as well as father, now that we know he intends to respond. We also have, the children are of Native American heritage, and we are waiting to hear back from 21 tribe representatives regarding that.
All right. I guess given the stability of the current situation, I guess I'll say it seems like we ought to push this out the full 60 days. So let's set this out to January 4. I'll extend the emergency guardianship through that time. And hopefully that allows us to get everybody served and hear back from the tribes.
Thank you, Your Honor.
All right, thank you. And you'll prepare that order, counsel?
Yes, Your Honor.
Yeah, this is Mike Forrest. I'm here.
Thank you.
This is Mike Forrest and my wife Carla as co-guardians.
And I understand the mother started a prison sentence yesterday, is that right?
Yeah, I think actually Tuesday night.
Okay. So what I am missing at this point is proof of service on either of the parents of the petition. Where do we stand on that, sir?
They were served.
On Monday.
I guess I didn't know what I was supposed to do for proof. I did on Monday when we picked up the girl. There was an acquaintance of mine that did serve him.
All right. Well, I need an affidavit from that person saying, you know, on this date at this time, I served these papers on this person so that we know that they've got notice.
Okay. How do I do that now that she's in jail? Can I just take something there and have her?
Well, yeah, you can have her served at the jail or at the prison. But I've got to have proof that they've been served before we can do a whole lot.
Okay, I should be able to do that today then. I did serve her with a copy that I got, but I guess I didn't know anything about the affidavit.
Yeah, we've got to have proof that the service occurred. And you're going to need to prove service on the father as well.
Well, so I have an assumed father, but I don't really know for sure who that is.
And I think that's the best you're going to do in this circumstance, and it may have to be by publication. It's up to you how you pursue this at this point. But this is a very difficult statute. A lot of its provisions are pretty unworkable. And navigating this without the aid of an attorney is difficult, to say the least. So I would urge you to consider asking an attorney for some help, especially on the service issue. In the meantime, I'm willing to extend the guardianship, the emergency guardianship order through a January 4 date, and I'll fill that order out here. In the meantime, you've got to get proof of service to the court so that we can do anything by that date. Understood?
I understand. I'll do it.
Thank you, sir.
Thank you.
And that will be all.